What do prosecutors have to prove to convict Karen Read of second-degree murder? Hello, my friends. My name is Brian, and this is LTL True Crime. If this is your first time over here and you like true crime, please make sure to subscribe, like, and comment down below. Turn on those bell notifications so every time I go live or I drop a new video, you will know. So obviously, lots of drama in the Karen Read case over the last 2 years. I've been covering this case almost close to a year now, and what we have uncovered, what we have talked about, the lies, the cover-up, and deception in this case is one of the wildest cases that I have ever come across in my entire life. And I can't believe that at this point, with everything that has brought out, everything that has come out in this case, I cannot believe that we're actually heading to trial. We have the FBI that has stepped in and investigated the investigation. We have multiple accounts, in my opinion, the Canton Police Department being corrupt in their investigation. There's an internal investigation into the lead detective, Michael Proctor, and there's been new information that is being shared now in that investigation. We don't know what that information is, but that was just talked about by Karen Read's defense in the previous hearing. It's unbelievable. I cannot believe that we're at this point. But let's get into this article here from Boston.com. So it goes on to say, what do prosecutors have to prove to convict Karen Read, second-degree murder? Prosecutors face a heavy burden of proof as they chase a second-degree murder conviction against Karen Read. So it goes on to say here, more than 2 years after prosecutors first accused Karen Read of backing her SUV into her boyfriend and leaving him to die on a snowy lawn in Canton, they face the ultimate task of proving their murder case before a jury in Norfolk Superior Court. And in a case rife with continuous evidence and conflicting theories, the Norfolk County District Attorney's Office carries a heavy burden of proof as it chases a second-degree murder conviction. I'm going to tell you right now, my friends, in my opinion, I don't think the Commonwealth is going to prove their theory. It just doesn't add up. And we hear more and more about this in these hearings of evidence that comes out to support Karen Read did not do this. I mean, the writing is on the wall. And I think when a jury looks at this, all of the information that's put out by the Commonwealth, I think it's going to be a hard time to convict Karen Read of these second-degree murder charges. So it goes on to say here in the article, prosecutors allege that after a night out with friends, Read killed Boston police officer John O'Keefe while dropping him off at a home of a fellow officer on January 29, 2022. Read's lawyers, meanwhile, say she has been framed in a cover-up and have suggested that other after-party guests are to blame. The Mansfield woman has pled not guilty to charges of second-degree murder, motor vehicle manslaughter while driving under the influence, and leaving the scene of a collision causing injury and death. One thing I will say this. One thing that is certain. Karen Read did have some drinks that night. They were out. They were at a bar. Her and her boyfriend and some friends were out at a bar. And it is obvious that they had a few drinks. I think that she'd probably be guilty of drinking and driving, but killing her police officer boyfriend, I just don't see it. So it goes on here to say the Norfolk County grand jury that indicted Read found probable cause that the 44-year-old did assault and beat John O'Keefe with the intent to murder such person, according to a copy of the indictment. However, while they were able to secure indictments during the grand jury proceeding, prosecutors face a higher burden of proof when Read's trial begins Tuesday. What do prosecutors have to prove in the Karen Read case? With crimes like this, you really have to prove three things. You have to prove the action, you have to prove that the action then caused a result, and you have to prove that you acted with a particular mental state, that you had a particular culpability, explains Daniel Medwed, a criminal law professor at Northeastern University. In Read's case, all three of those seem to be a little tricky, Medwed said. I mean, if they can prove that her car was what struck him, then they can prove the assault, and then they can prove the causation, that the assault caused his death. But I think it might be hard to prove that given the third-party suspect evidence. It goes on to say, in Massachusetts, prosecutors trying a second-degree murder case must prove not only that the defendant caused the victim's death, but that the defendant either intended to kill the victim, intended to cause the victim grievous bodily harm, and intend to commit an act that a reasonable person would known to create a plan and strong likelihood that death would result, per model jury instruction listed on the court's web system's website. Now, the problem that I have with all of this is that the Commonwealth has been trying to frame Karen as this very angry person, that she just probably didn't want to be with John anymore. They argued all the time. So what? Couples fight. They have issues. That doesn't mean that Karen got so angry that she's going to just kill her boyfriend. It doesn't make any sense. Couples fight. That's what happens in relationships. Just because you fight doesn't mean that you're a killer. Given Reed was seemingly unaware the morning of January 29, 2022, of what allegedly happened the night before, proving that it was her intent to assault him or leave him for dead is going to be much harder, I would think, Medwed said. Motive is often used to prove intent, he explained. Prosecutors have pointed to Reed's reportedly fraudulent relationship with O'Keefe and allegedly left him a series of heated voicemails around the time he died, screaming, "John, if I effing hate you," and accused him of having an affair. Again, people fight in relationships. It doesn't mean that she's a killer. What's at stake with a possible third-party culprit defense? Medwed also noted a possible disconnection between Reed's second-degree murder and OUI manslaughter charges. There might be an argument that it's sort of like a prosecutor want their cake and eat it too, which is like she's a cold-blooded killer who left him for dead, but she also was too drunk to really understand what she was doing, and she's a manslayer, he said. It's hard to square those two things, right? He acknowledged it's possible for prosecutors to tell a story that weaves together both theories, but proving causation would be tricky if Judge Beverly Cano allows Reed's lawyers to argue the third-party culprit defense, i.e. pointing fingers somewhere else. That would be at the people and side 34 Fairview. Prosecutors have filed a motion in limine to prevent the defense team from doing just that, asserting that the arguments set forth in the defendant in pretrial motions contain only vague interferences, rank speculation, and scant details of who, if anyone, had the motive to intent to appropriate to kill the victim. That motion in limine, in many ways, I think, might be the key to this case, Medwed said. No matter whether it is the intent crime or the OUI manslaughter crime, the third-party suspect piece is going to undercut causation, that her behavior caused his death, he explained. So that is really the key to this whole case. Is the jury going to get to hear about the evidence pointing to the third-party suspects? And if they do, a chance to hear it, what exactly will it consist of? Medwed emphasized that the admissible evidence at trial and the facts available for public consumption in the courtroom documents, media reports, and blogs may not be the one and the same. And the contrary to the TV legal dramas, a defense lawyer just can't throw something up on the wall and see if it sticks. The thing is that they have to put on the walls and has something grounding in the evidence, he said. The key takeaway on this is you don't have to prove that someone else did it, Medwed said of the defense. You just have to prove that there's not enough evidence that someone else could have done it so that it creates a reasonable doubt about whether the defendant did it. From there, it's up to the jury to decide. It's really important to understand that just because something is admissible doesn't mean it's proven, she said. It just means that the defense gets to introduce it to the jury, and by introducing it to the jury gets to consider it, but it doesn't mean the jury has to agree with it, right? Just because you sell something doesn't mean someone else has to buy it. I think it will be hard to convince 12 jurors from Norfolk County. Jury selection also poses a challenge for prosecutors, given Reed's case has attracted widespread media coverage and sowed residents' mistrust in the local law enforcement. To find jurors who haven't been sort of tainted by all this evidence of conspiracy might be a challenge too, Medwed said. At this point, Medwed said he'd be surprised if Reed were ultimately convicted on second-degree murder charges. A lot of that hinges on my belief that the third-party suspect evidence will come in, he said. Also, that hinges on my next step analysis, which is that the third party evidence is going to be fairly strong, and both of those things haven't been shown yet. And that's the thing people have to keep in mind. This is just the tip of the iceberg of what we've had privilege to see that's been reported in the media. But he continued, since I think those things are true, I think it might be hard to convince 12 jurors of the Norfolk County that she intended to kill this guy beyond a reasonable doubt. Assuming Reed's lawyers are allowed to argue a third party culprit defense, and depending on how compelling jurors find their evidence, Medwood said that the jury could possibly acquit Reed on all counts or land somewhere in the middle, acquitting her on the murder charge, but convicting Reed of OUI manslaughter. With a hearing on the docket for 9 a.m. Friday, Cano may decide whether the defense can argue that someone else was responsible for O'Keefe's death. But a bigger question, which will be unanswered until the trial, is even if the defense is allowed to sell it, and will the jury buy it? Medwood noted those are totally different questions. So, great little article there from Boston.com. Again, Cano, we just had the hearing on Friday, so this came out just before that. But she took it under advisement. She's going to rule on it if this third-party culprit defense will be allowed in the court during this trial. So lots of things here going on in the Karen Reed case. It's going to get very, very interesting. I believe this is going to be one of the biggest trials of all time. It's attracted a lot of viewers, and it's starting to attract a lot of attention. So we will continue to cover the case here. I do a lot of lives on this, and I'll be dropping some regular videos as well. I want to thank everybody for watching my video today. Again, if this is your first time over here, please make sure to subscribe, hit the bell notification, turn that on, leave a comment down below. Let us know, do you think that Karen Reed killed her police officer boyfriend, or is Karen Reed being set up in a conspiracy cover up what actually went on at 34 Fairview? Thanks, everybody. Until next time, I'll talk to you soon. Take care.